はい、それでは次の講演を始めさせていただきます。続いては国境を越えたデータへの法執行機関のアクセス、提案された EU エビデンス規制の国際的な範囲についてアナマリア・オスラさんにお話しいただきます。アナマリア・オスラさんはエストニアのガードタイムでシニアポリシーオフィサーを務めていらっしゃいます。彼女は日本の早稲田大学に留学後、エストニアの NATO CCD COE にて勤務され、国内のサイバーセキュリティ戦略や国際法を研究されています。アナマリアさんからは今回のテーマについて動画をいただいております。そちらをご覧いただきまして、動画が終わりましたら皆様からスライドに寄せられた質問を直接ご本人にお伺いしていきたいと思います。Our next session is Law Enforcement Access to Transborder Data, Global Reach of the Proposed EU E-Evidence Regulation. Please welcome our speaker, Anna Maria Osla.
Hi everyone, my name is Anna Maria Osula and I am working as a senior policy officer in Guardtime, which is an Estonian technology company, and also as a senior researcher in Tallinn University of Technology. I'm very happy to be speaking in this conference. I had the pleasure to attend Code Blue a couple of years ago in person. It was a great experience. It's a pity we have to now deliver presentations using the screens, but nevertheless, thank all the organizers for inviting me here and for putting together such a neat event. I will today share with you my research concerning law enforcement's access to transborder data. And I focus on the ongoing initiatives regarding regulating law enforcement's access to data that is located abroad, and also talking about the element of the global reach of this regulation and how this relates to international cooperation. This presentation is partly based on an article I have written with Professor Dan Svantesson, and which will be published next year, and which has been supported by the Masaryk University Research Project. I will start first by explaining what are the current means for transborder access. Then I will turn to the legal basis of such access, and I will finalize with discussing what these proposed regulations mean for international cooperation. First of all, why do we need to talk about transborder access at all? I think the audience of this conference is well aware of the wide use of ICTs, of the increasing number of devices we and our societies are using every day. This also, unfortunately, brings along the increase of malicious cyber incidents. And this means that law enforcement, when investigating cyber incidents or any type of incident actually, will most probably need also to take into account electronic evidence. In fact, European Commission in 2018 has published a report saying that more than half of all investigations involve a cross-border request to access electronic evidence. So this means that modern technologies are not only changing the way the bad guys carry out their malicious actions, but also modernizing and making more effective the use of tools that law enforcement can employ when investigating these offenses. So it is clear that law enforcement needs to quickly access the evidence, but how do you do it when often the evidence is located outside the domestic territory of the law enforcement itself? So unfortunately, when we look at domestic regulations about criminal procedures, then these are often dating back tens of years. which means that they are not really up to date and not really taking into account the modern investigation techniques and the current situation where often electronic evidence is not located on the territory of the investigative state. Because this used to be the situation before, that often most the evidence would be stored domestically. And before I begin with describing different means that are used today for accessing such evidence, I have here two examples of incidents. These incidents are well known, the Yahoo data intrusion and the Equifax data intrusion. But what is perhaps not that well known is how much money Yahoo and Equifax had to pay in damages for its users and for affected individuals. So, resulting successful class action settlement in the US, they had to pay 117 million US in the case of Yahoo and 700 million US dollars in the case of Equifax. So this really means that it's not only a question about law enforcement and about criminals, but it's also the question of these companies or these states or these government institutions that are being the victims of such incidents. So relevant for all of us. So then how can we get the evidence? There are several options for accessing evidence that is located extraterritorially. The most well-known of them is the Mutual Legal Assistance System, also known as MLATs, Mutual Legal Assistance Treaties, which are usually bilateral agreements between countries. They can be in the form of conventions, in the form of simple agreements. And these are binding together then different national entities that can cooperate then with other entities from the other countries in case there is a need for extraterritorial evidence. But the procedure for the mutual legal assistance is often heavily critiqued. Why? Well, there is a report from 2012, and think about it, that's already 8 years ago, where the Council of Europe is saying that the MLA system or the process is inefficient in general and with regard to obtaining digital evidence in particular. So why? What is wrong with the MLA system that used to work so well for many years? Well, the response is obvious, because the circumstances have changed. So you don't have any more the situation where often most the evidence that you need is located on the domestic territory. No, now it is located extraterritorially, and furthermore, often you don't know exactly on the territory of which state it is located. So what are the downsides of the MLAT process? First of all, time. This system takes time. It can take up to months, up to 6 months, for the law enforcement entity to then actually receive the information it has asked for. And for my research, I have conducted interviews with several experts, and I had one expert from the Estonian Ministry of Justice who was comparing the MLAT system with a message in a bottle. So you send out your message in a bottle, you don't know when the message is received, you don't know when or who opens it, and you don't know whether a response has been sent or when it would arrive. So it is really difficult to operate with the MLATs and with such uncertainties regarding time when you live in such a fast-paced world. So we know that with digital evidence, you can just click a button and the evidence is gone. So if you have to wait for this evidence for 6 months, so many things can happen meanwhile. Additionally, MLATs may not be agreed upon between all the countries. So if you don't have an MLAT in place, you would need to operate, for example, based on diplomatic relations. The MLATs often, as said, have been agreed many years ago. They're not up to date, especially when it comes to the procedures and necessary measures that are needed for today's investigations. And of course, the other party may decide not to cooperate. So this is a diagram that portrays the possible journey of this MLAT request from one prosecutor to the other prosecutor from the other state. So you can see how cumbersome this journey actually is. Now, apart from the MLAT system, there are of course other options. Within the EU, there are networks such as Europol and Eurojust. For larger international affairs, you could use the help of Interpol. Some countries have established 27 points of contact networks. This is, for example, a requirement for some international agreements. And then there is, of course, also informal or formal cooperation between law enforcement agencies. But still, there are challenges. The foremost is speed that we already mentioned repeatedly. And the second one is what I alluded to already before, which is known as the loss of knowledge of location. So it is not that we have a loss of location. No, the data is still somewhere, but we cannot exactly always pinpoint at exactly on the territory of which state the data is currently located. And this is something that has been admitted also, for example, by Google itself, because with the wide use of cloud computing, having servers and the network architecture the way it is, often some pieces of data may be located in different locations at the same time, or somewhere where even Google would not be able to say where exactly the data is. So this means that it is increasingly difficult to understand where the data is or where it isn't. Therefore, it is increasingly difficult to choose the right procedure for accessing this data. And why is this relevant? Because we need to keep in mind how the data was received, whether the procedures that are currently put in that state, whether these procedures were followed correctly, and if these were not, then this evidence can be said to be inadmissible in court. So it's really relevant for the law enforcement to have the necessary tools set and to follow the rules that are being adopted within their domestic frameworks. So what are the legal basis for such an access? And this is a very, very wide topic. I will offer a very brief kind of summary. The legal basis for such access can be divided into the international law matters and domestic law. I already mentioned on my last slide elements of domestic law, that law enforcement needs to keep in mind the domestic procedures, and if these are being breached, then the evidence can be called inadmissible in court. So this is why the domestic law is really relevant. There are many examples of regulation in different countries. Different countries have approached this differently. Also within the EU, we see different domestic approaches. One of the recent notable example of a domestic regulation comes from the US Cloud Act, which requires the internet service providers, ISPs, to hand over data to US law enforcement agencies, no matter where the data is stored. Also, the US Cloud Act foresees bilateral agreements with qualifying foreign governments to ensure there are more clear procedures in place between different countries. But the US Cloud Act is a great example of the shift that I'm talking about. So we're not anymore talking about the state-to-state cooperation when it comes to receiving evidence located extraterritorially. This is the way it used to be, basing this procedure on the concept of territoriality. But there's a shift to the state to ISP or service provider approach. So we are not anymore talking about a communication that is strictly between states as the main actors, but we have included here now also the main actor as a service provider. And this is really a great shift that we see in the regulation domestically. And this also, of course, reflects on the international level, where there are two things to keep in mind in the context of international law. First, that such transborder access can be based on international agreements that we talked about before. An example of such an agreement is the Council of Europe's Convention on Cybercrime, also known as the Budapest Convention, which allows to access data when the data is located on the territory of another party. Of course, there are many elements and certain ambiguities also related to this regulation, but it is an example of how this can be done. And Council of Europe is currently also working with possible amendments as their second additional protocol, which would clear up a couple of things in this regard. And another example of an international agreement is the EU regulation that I will be talking about in my next slides, because this EU regulation would form unified rules between all member states. So in that sense, it would really create a precedent. And the other element of international law that we need to take into account are the basic rules, basic principles of international law, such as sovereignty. So the question arises whether, if the law enforcement of one state decides to access digital evidence located on the other state without asking that state first, without notifying that state, whether this could be considered as a breach of sovereignty of that state. So that's a very, very interesting question. And there is no universal consensus in this regard as we speak. But I can say that when we observe different international and domestic developments, then we can see that more and more states are accessing such information without notifying in advance or without asking for the permission of the other state in advance. So what are the cornerstones of the European Union's proposal? The e-evidence project includes two main proposals, and here on the slides I have outlined the main points of these proposals. First, to create a European production order. This would allow a judicial authority in one member state to request electronic evidence directly from a service provider offering services in the EU. Now again, it's not asking from the member state, but asking directly from the service provider, what we already talked about before. And important to note here is also that the service provider does not have to be based in the EU, but it has to be offering its services in the EU. This means that, for example, a Japanese service provider based here in Japan, but offering its services to within the EU must, if this proposal is to be adopted, must follow these rules as well. And service providers will be obliged to respond within 10 days and within 6 hours in cases of emergency. This is quite an improvement from the previous regulation. Also, the proposal offers a tool for preventing data from being deleted. This is called the European Preservation Order, which will allow to preserve specific data to enable the authority to request this information later via other means, such as MLA. And these proposals and these tools would, of course, include strong safeguards and remedies in order to make sure that the basic rights are being protected. But importantly, for those service providers who are not based within the EU, for example, who would be based in Japan, then the new framework would oblige the service providers to designate a legal representative in the Union. And this would ensure that all service providers that offer services in the EU are subject to the same obligations. So that would mean to harmonize the rules towards different service providers. And the wider aim of this would be to provide legal certainty to businesses and to service providers. And this would also provide certainties, of course, to the law enforcement, because law enforcement authorities often depend on the goodwill of service providers to provide this information. So currently the situation can be quite uncertain when it comes to whether law enforcement would actually receive that information from the service provider. If the service provider is a foreign one, it can decide currently on its own whether to provide the data or not, unless there is a special agreement in place. Now, in addition to these proposals that I just discussed, there are also negotiations ongoing regarding international cooperation. This include, firstly, a specific agreement with the US regarding accessing data stored by the large service providers which are US-based. As we know, majority of service providers that are being popularly used within the EU are US-based, so this is of course very relevant. And also regarding the second additional protocol of the Budapest Convention that we already mentioned. There are also examples of data nationalism or localization regulation that are being discussed in different countries. This means that those different countries oblige their service providers to store all the data domestically. And so this is also up to debate how useful this would be in regard to international cooperation. This is a very interesting topic. One thing I must say that the discussions at the European Union are currently ongoing. There is a lot of debate regarding these issues. I have included some references in the end of this presentation about the most important arguments and proposed amendments. And the most important or the most famous amendment in this regard comes from the Member of Parliament Birgit Sippel, who has published a report, also referenced in the end of this presentation, which identifies a number of possible weak points in the proposed regulation. So that there is a lot of debate ongoing within the EU on how to move forward with the possible regulation. So I repeat again, it is currently as a draft. But clearly, we see a global reach of the proposal. As I already discussed, we don't have anymore the state-to-state approach, but the state-to-service provider approach. The service providers would be obliged to have a legal representative within the EU. And most importantly, we are not focusing on the physical location of the data, but rather focusing on how to access the data. When we talk about the Japanese example, then I think Japan is in a special place because of the successful cooperation with the EU regarding the GDPR. So I think this can offer good grounds for also expedited cooperation between the EU and the Japanese law enforcement entities. And also, once successful, I think the European Union regulation could serve as possible model law. What we can see with GDPR, how different countries are basing their regulation on some of the key principles of the GDPR, and if successful, this e-evidence project could serve the same purposes. But what are the challenges and what are the possibilities for international partners? Well, first of all, I think there will be a lot of debate and discussion about the actual role of service providers. I already mentioned a number of obligations that service providers would have if this proposal would be adopted. But also we must ask whether it is really sensible to increase the level of service providers to such a great extent. For example, in regard to the responsibility of protecting human rights when they have to decide whether they will give out information to the law enforcement entity. This law enforcement entity may be from the European Union and may come within this well-established and hopefully transparent framework. But what if the request comes from a rogue state? What if it comes with a state with whom you don't have such good cooperation? Should you, and on what terms, should the service provider then provide the information? Then also there are questions regarding safeguards, human rights, when it comes to possible question of notification. Should the other country be notified about such data being requested? Should it be notified in advance, or should it notified after the access has taken place? So this all relates to effective legal remedies. Then I already mentioned sovereignty, possible conflicts of law with different states, which may be the basis for possible challenges when it comes to cooperation, international cooperation. But hopefully what such regulation will amount to is that the investigations will be more effective and will be fast. And in a way, it is really setting a precedent as a new form of cooperation between the states and between service providers. So global trends, as I have explained already in my presentations, are that the traditional state-to-state approach is changing. There is a large shift in the paradigm of international cooperation. The focus is not that much anymore on the traditional territoriality principle, but rather the focus is on how to access the data. So, conclusions. I think it is clear that states cannot accept impunity for criminals. This means that states, regional organizations, and the global community have to come up with a workable solution for this. And it is best for everyone if this solution is as transparent as possible, taking into account all the different challenges and questions we have talked about. It is really a time of change. We see much more clarity also. It is slow, but it is emerging. The clarity in domestic regulation, so different countries are updating their domestic laws when it comes to transborder access. But at the same time, there's a lot of room for interpretation and a lot of room for debate. For example, regarding the threshold of the breach of sovereignty, regarding the exception of loss of location. And as already mentioned before, regarding the role of service provider in international cooperation. One thing that we can also observe is a certain dissonance between the actual state practice, what the law enforcement entities are actually doing, and between the regulation that is written in their domestic laws. So to finalize my presentation, I would say that more transparency in domestic approaches is absolutely welcome and is needed. And we also should welcome EU's attempt in trying to adopt a regulation that would harmonize the approaches of all the member states. And I believe that given that all the challenges we have discussed about, and I'm sure there are many more that we didn't have time to target today, given that these are being taken into account, I think this can really improve law enforcement's ability to fight crime. Here are some of the references if you are interested in these topics. And with this, I thank you for listening, and I am ready to answer to the questions from Tallinn. Thank you.